Good morning, everyone, and welcome to today's Beasley Allen webinar, Alabama Lawyers Ethics, Changes and Resources That You Need to Know About. My name is David Byrne, and it's my pleasure to introduce our two distinguished speakers for this important practice-related topic. Today, we're honored to welcome Alabama State Bar General Counsel Roman Shaul and our current Alabama State Bar President and Beasley Allen Principal, Gibson Vance. Together, Roman and Gibson will examine the State Bar's disciplinary process while emphasizing expectations within an ever-evolving technological landscape. They'll also discuss proposed rule changes and their implications, and they'll identify the resources that you can turn to when you need ethics advice. While we're waiting on the last of our registrants to join us, let's take just a few moments to meet our two speakers. In 2018, Roman Shaul was selected by the Alabama Board of Bar Commissioners to serve as the organization's general counsel. Roman previously served as a circuit judge for Alabama's 15th Judicial Circuit, and he spent over 19 years in private practice in firms in Tuscaloosa and Montgomery County. During his time in private practice, Roman served as the president of the Alabama Bar's Young Lawyers section, and in addition to his Alabama bar admission, Roman has been admitted to practice in Arkansas, Georgia, Louisiana, Mississippi, South Carolina, Tennessee, and West Virginia. Roman is a tireless supporter and advocate for our state bar members, and we are so delighted to have him on today's program. My partner, Gibson Vance, is a longtime member of Beasley Allen's personal injury and consumer fraud sections, and during the course of his career, Gibson has handled dozens of highly successful jury trials. And in his spare time, he's managed to hold nearly every top position that a lawyer can have at the county, state, and national level. Gibson has served as the president of the Montgomery County Bar Association, the president of the Alabama Association for Justice, the president of the American Association for Justice, and he's our current Alabama State Bar president. Now, if all that weren't enough, Gibson was elected President Pro Tem by the Board of Trustees for his alma mater, Troy University. I am honored to call Gibson Vance my friend, and I'm very happy to have him join us for today's webinar. Now, before I turn the program over to our speakers, I need to go over just a few CLE-related notes. First, today's webinar has been approved by the Alabama State Bar for 1 hour of CLE credit. In order to receive full credit for attending, you've got to stay on for the duration of the program. A link to today's presentation was included in the Zoom confirmation email you should have received when you registered. But by the end of this week, you'll receive another email with an evaluation form and an updated presentation and video link. You can email your completed evaluation form to webinars@beasleyallen.com. This webinar is being recorded, and for those Alabama attorneys who are participating today by phone, please email us your name, phone number, and state bar ID number. You can send that information again to webinars@beasleyallen.com. That will ensure that we help you receive full CLE credit. Also, be sure to check out the events page of our website, beasleyallen.com/events, as we'll be adding more webinars throughout the remainder of this year and into 2023. Our next webinar is another Camp Lejeune update. It's set for Wednesday, November 30 at 12 p.m. Central. Finally, if you have questions during today's webinar, I want to encourage you to use the question and answer feature located at the bottom of your screen. We're going to set aside time at the end of today's program to try and tackle the questions submitted by all our viewers. So with that, Roman, Gibson, let's get started.
Thanks, David. Appreciate that.
David, that's a great introduction, son. After you get through practicing law, you may want to go into broadcasting. Well done. Well, welcome to everybody. I know we have several hundred lawyers throughout the state that are participating in this Zoom CLE, and we're excited about it. Roman is a good friend of mine, a former law partner. We're doing this from my office. So, Roman, welcome back to Beasley Allen.
Thanks for having me. Yeah, it's been a while since I've been in this office. In fact, this might have been my office at one point. So.
Well, Roman, you do a great job at the state bar. And I don't think that most people understand exactly what your role is with the state bar and how it's a little bit different from the office of the state bar, We have an executive director. We have 40 employees that do various functions for the state bar. But your group as general counsel is a little bit different.
That's right. So this is something that I'm not sure I quite understood before I got this job. So the Alabama State Bar is a creature of statute. The legislature passed a statute in 1923, I believe, creating the Bar Association, or at least the beginnings of what is now the Bar Association. And so the bar itself is a creature of statute. However, my office is a creature of rule. As most people know, the Alabama Supreme Court is tasked by the Constitution of the state of Alabama to regulate the profession of law. They do this through my office and the system that they set up. But my office is actually a creature of rule. Rule 6 of the Alabama Rules of Disciplinary Procedure creates the Office of General Counsel, and it sets out our authority to regulate the profession of law in the state of Alabama. And of course, we are just one step in the disciplinary process that the Alabama State Bar set up. The Alabama Supreme Court has final authority over all discipline and all rules that we use.
Well, Roman, before we get into the nuts and bolts of your office of General Counsel and disciplinary, it's incumbent upon us as bar leaders to let our members know exactly what the bar does for them. We have various programs, and I'm going to ask you, if you would, to highlight a few of those at this time.
Sure. So my office speaks at about 80 different CLE events a year. And although we are a program within the bar, since we are speaking to so many lawyers, we like to take that opportunity to enlighten our membership on some of the things going on what we call the bar side of things. And so one of the programs right now that the Alabama State Bar is pushing is our member benefits. Most of you who are members of the Alabama State Bar, by virtue of your membership, receive certain member benefits and certain discounts. And there may be discounts on services that you're already using. So for example, there are gym discounts, there are shipping discounts, there are clothing discounts, there are automobile discounts. And so the Alabama State Bar is constantly trying to update and increase the level of member benefits. So we would ask that you please check that section of the website, check it frequently, because we're always trying to update that. Also, we have launched an electronic newsletter that goes out on Mondays. We call it The Scoop. Melissa Warnke is our communications director. If you don't get The Scoop, please email Melissa. The Scoop really is a very concise information, one-stop shop of information of what's going on in the bar, what's going on in the legal profession in the state of Alabama. And it's also where we're pushing out a lot of free CLEs and other things like that you'd be interested in. Also, this year we're having a mid-year meeting. If you're interested in that, that's January 18th to the 20th. It will be in Mobile. And then we're constantly trying to tell people about certain bar programs. So one of the bar programs that we like to talk about is PMAP. You see there on the screen. That stands for the Practice Management Assistance Program. That's the bar's program designed with helping lawyers with the business side of practicing law. You know, lawyers are often very good at what they do, maybe not quite as good as on the business side. So that's the bar's program designed to help.
Yeah, they don't teach us in law school how to run a business. Several things that we do with PMAP is we teach you how to work a trust account. Roman, you'll talk about that later. A lot of lawyers get in trouble with their trust account. PMAP also provides you with a research tool, Fast Case, for free. Doesn't cost anything. You can do your research with that. ALAP.
Right. ALAP stands for the Alabama Lawyers Assistance Program, and we'll talk a little bit more about that later. ALAP is a program that the bar has. I think every bar association in the country has one, but it's really designed to help lawyers who are struggling with either mental health issues, substance abuse issues, and things of that nature. There's some very real reasons why, if you are struggling with something like that, that you would contact ALAP. Same thing with PMAP. If there's something that you're struggling with, there's some really good reasons why you would call them. And I will talk a little bit more about that in just a minute. And then lastly, one of the programs we always like to highlight is the Volunteer Lawyers Program. Linda Lund's group, they do really a great job, and really the bar puts a big emphasis on making volunteer lawyer opportunities accessible for everyone and really kind of easy, where all you have to do is show up. They try to do a lot of the work, and they just want you to show up, be the lawyer. So if you're interested in pro bono type work, the Volunteer Lawyers Program and our website is a good place to start.
And we as Alabama lawyers do a really good job there. We lead the country in number of hours that each lawyer gives to voluntary legal services. 45 hours on an average each lawyer utilizes free legal service.
And I will say this, Beasley Allen also within that group leads, is very instrumental in a lot of the volunteer lawyer programs. I attended a luncheon the other day where Beasley Allen received one of the top awards for the number of volunteer lawyer hours. So you guys are to be commended for that.
What's important, we have to help. Well, as president, I have two initiatives. We call it Drive for Five. Our staff at the Alabama Bar came up with this logo. That is my dog. His name is Jack. That was my wife's idea to put him in the car with us. And what are we doing this year? Well, we're doing two things. We're traveling to all 41 judicial circuits in Alabama. Roman and I go to Russell County tomorrow. If you're listening from Russell County, please come out and have lunch with us. I think it's important that we as bar leaders bring the message of the bar to the members of the bar. For too long, I think lawyers who have not really been exposed to what the bar can offer them think that the bar does two things. We take your dues and then we try to take your license. Well, neither one, well, we do take your dues, but we certainly don't try to take your license. There's so many programs that we as the Alabama State Bar offer to our lawyers. And so we're going to travel to every circuit in the state and let them know exactly what the bar does for them. Secondly, and perhaps more importantly, is we want to put lawyer wellness in the forefront. The reason for this is a very serious reason. Look at these statistics. I had no idea that suicide is the third leading cause of death among attorneys. I doubt anyone listening to this seminar knew that. Third leading cause of death among attorneys. 36% of attorneys consume alcohol at levels considered problematic. 36% of attorneys struggle with substance abuse. 28% report depression. 19% anxiety. And then look at this last stat. 40% of law students report severe anxiety upon graduation. Well, we were there when they were taking the bar exam a couple of months ago, and you could feel the anxiety throughout the room. But that's a shocking statistic to me. I think it has a lot to do with the difficulty young lawyers have in finding a job, the amount of student loan debt that they have. But that is a shocking number. So what are we going to do about it as bar leaders? Well, we've established what we call Drive for Five. We as a state bar, we're offering to any lawyer, any law student, any judge, 5 free hours of counseling. All you have to do is call this 1-800 number and you will speak with a counselor. You will tell them what your issue is, whether it's drug or alcohol abuse, anxiety, depression, marital problems, financial problems, and they will put you with a counselor that can help you the best. Now, in addition to this being free, once again, every lawyer gets 5 free hours. When Roman and I and our executive director, Terry Lovell, were discussing how to implement this program, we saw one impediment. That impediment was that lawyers who do a good job of taking care of their clients and don't do a good job sometimes of taking care of themselves would be afraid to utilize this service because they would be afraid that somebody would find out about it. Not only is it free, it's totally confidential. The bar never knows who's using the program. The public will never know who's using the program. We've contracted with a service of providers. At the end of each month, they send us a bill. They tell us how many lawyers utilize the program and how many different sessions each lawyer had, and we paid for it. No questions asked. The identity is ever known. So my message to you and our message as we travel around the state is that if you need this service 24/7, you can do it via Zoom, via phone, or in person, anywhere over the state. Call this 1-800 number and get the help that you need. And if you don't need the help, I guarantee you, you know someone in your community, a lawyer or a judge that can utilize it. It's free, it's confidential, please utilize it.
Well, yes, I'm going to go back to this real quick because I want to talk about one thing. First off, the Office of General Counsel is very honored to help Gibson and the State Bar in promoting this program and this initiative. It is, when I was a a circuit judge and I would have a criminal defendant in front of me, oftentimes the whole reason that person was in front of me was because there's an underlying mental health issue or an underlying substance abuse issue or something along those lines. And as someone who now has to prosecute lawyers, when I see disciplinary cases of lawyers before me, oftentimes it's the exact same thing. There's an underlying mental health issue, there's an underlying substance abuse issue or drug issue, and this initiative really will go a long way with helping our membership. The bar has had a program, again, we call it ALAP, the Alabama Lawyers Assistance Program, but this is separate. All right, and I think this is actually I don't know. I can't say that it's better than our program. I can just say that it's a little different, and it really presents itself in a way to really reach people who are, as Gibson described, maybe worried about the stigma. Because when you call this 1-800 number, you see this Corp Care logo, you're going to get someone from Corp Care. That's a third party. We're never going to know who calls that. All we're going to know is that a certain number of lawyers contacted. And so that's how this program is a little different than ALAP. But let me talk about ALAP because, I work with the ALAP lawyers. There's a committee, there's a dedicated group of lawyers in this state that serve on the committee, which helps promote the Alabama Lawyers Assistance Program. If you contact ALAP at our office, or if you contact one of the lawyers on that committee, then every conversation you have is confidential, and that is important. It is confidential, which means they will not turn you into any other part of the bar. They will not turn you into the disciplinary office or my office. In fact, if you look at Alabama Rules of Civil Procedure 8.3C and D, it specifically says that employees of the ALAP program are forbidden from disclosing information related to a lawyer's interaction with that program. So they are forbidden from telling anyone, and that's to encourage you to get the help. But if you look at the committee comments, it talks about how the whole purpose is to encourage judges, to encourage lawyers who have these problems to call and reach out and get help. But if you look at the comments, it also talks about not only calling the Alabama Lawyers Assistance Program, but remember earlier I was talking about the Practice Management Assistance Program. They have an exemption too. So if you call them with an issue that you're having within your office, maybe a trust accounting issue or something, and they uncover some type of unethical behavior, they are also prevented from talking to anyone else or to turning you in and telling you about telling anyone else about your problems. Now, that level of confidentiality is so strong. If you look at the committee comments below, it says all inquiries will be treated confidentially as though it is a lawyer-client relationship. So it's essentially the same type of confidentiality that you get in the attorney-client relationship. And again, we know how important that attorney-client relationship is. There's some other reasons why, if you are struggling or someone else is struggling, that you would encourage them to call ALAP. Because oftentimes when someone figures out they need help, they've already got disciplinary problems. The Alabama Rules of Disciplinary Procedure speak to that issue too. So under Rule 27E of the Alabama Rules of Disciplinary Procedure, if we have any open disciplinary files and someone calls ALAP, it will stay our proceedings. Assuming that person agrees with ALAP and decides to get help under the ALAP program, our disciplinary proceedings are automatically stayed. And so the reason is so that person can go get the help that they want. And we encourage that. And I tell people this: if you sign up with ALAP, okay, even if you know you have disciplinary problems, and we know you have disciplinary problems because we already have a file open, if you sign up with ALAP and you do the things that you're supposed to do, and you get the help that you're supposed to get, when you come back out from under ALAP and we have to deal with the disciplinary problems, the person I'm dealing with on the back end is a different person than the person who is struggling on the front end. And I promise you that your results and what's going to happen on the disciplinary side is going to be a lot more lenient, and it's going to be something that's going to be a lot more palatable to you than if you don't deal with your problems on the front end. The Alabama Bar Association really undertook in 2016 and 2018 a broad study of lawyer wellness. And in that detailed report, one of the conclusions that they had was that a lawyer's well-being is so important. It really rises to the level of an ethical duty, right? That task force said that lawyer well-being is part of a lawyer's ethical duty of competence. We all have a duty of competence. It said it includes a lawyer's ability to help themselves make responsible decisions for their clients. And I think kind of the takeaway from this is if the lawyer's not in a good position and they can't make their own personal decisions, they probably shouldn't be trying to make decisions for other people. So another thing, since we're talking about mental health, I get these calls from lawyers that say, Roman, my client is struggling. My client is suffering from some mental health issues. My client threatened to kill himself. Roman, my client threatened to kill me. What do I do? And so some of you may have seen this slide before because I try to put it in a lot of our presentations because it's so important that I want you to know the rule when the crisis occurs. I'll talk about in a minute my ability to give you ethics advice and how I want lawyers to call me when they have an ethics question. But sometimes when a client is in distress, you don't have time to call me and get an ethics opinion. So I try to cover this in most of my presentations. So here's the rule. Rule 1.6 is the rule on confidentiality. Rule 1.6a, which I'll talk about in a minute, really just kind of says you've got to keep your client's information confidential. But there's an exception, and the exception is the B subpart. The B subpart says that a lawyer may reveal such information to the extent the lawyer reasonably believes necessary to prevent the client from committing a criminal act that the lawyer believes is likely to result in imminent death or substantial bodily harm. So if you have a client in distress, you can reveal enough confidential information to get them some help. That may be calling law enforcement. That may be calling their spouse. That may be calling an adult child to come get them some help. All right, it's not a blanket waiver of confidentiality. You can't disclose all of their secrets, but you can disclose enough confidential information to get that person some help and to keep yourself and your staff safe if that's in fact the situation. Another close kind of issue we see is where you're dealing with a client and the client has some type of diminished capacity. That could be because of age, that could be because of some personal injury. And so how do you deal with that client when they have a diminished capacity? So rule 1.14, which is also kind of an exception to your duty of confidentiality, sets out how you deal with clients who are impaired. So the rule basically says you should try to maintain a normal relationship if possible. So for example, if your client has more lucid periods in the morning, then maybe you ought to reach out to your client and just contact them in the morning and talk to them. Don't talk to them in the afternoon after maybe they've been drinking or something, where they're suffering. But the rule also says, again, you can disclose the limited information to get the client some help if you think they are at risk of substantial physical injury or financial harm. So if they're doing something in a way or they're not doing something that you think is going to put them at risk either physically or financially, again, you can disclose enough information to get them some help. Maybe again, that's contacting an adult child, that's contacting a spouse, maybe it's contacting the court, setting up a conservatorship or guardianship to get that person some help and keep them protected. Again, not a blanket waiver of confidentiality. You can disclose just enough information to get them some help. But this is a big tool that you can use when you do have a client that's suffering from impairment.
So as we said earlier, Roman, your office is separate from the Alabama State Bar. And I've had the pleasure, I think we've been to 20 circuits now, traveling over the state. We have 21 more to go. But I love your presentation because I think, as I said earlier, lawyers who do not understand the process think that the general counsel's office is sitting there looking at files, calling balls and strikes, deciding who's going to get in trouble and who's not. It's really a heck of a process that you go through to ensure that all the rights of the lawyers are protected.
Yeah, and so one of the things I like to cover in the Alabama, when I do these presentations, is talk a little bit about the disciplinary process, because when I stepped into this role, I understood that there was a perception about my office, but I didn't understand the level of misperception that there was. We have rules. Everybody's familiar with the Alabama rules of civil procedure, the Alabama rules of criminal procedure, but we have the Alabama rules of disciplinary procedure. We have the Alabama rules of professional conduct, which you study about in law school if you go to law school here. But then we also have the standards for imposing lawyer discipline. These are all rules that the Supreme Court has adopted that defines what we can do, what we can't do, and what the appropriate level of punishment is given certain situations. But one of the things I like to talk about is kind of this snapshot statistic. Some of you may have seen this before or different versions of this. So in 2021, we received 882 complaints against lawyers. Now, those complaints are oftentimes from disgruntled clients, but sometimes they're from opposing counsel. Sometimes they're from judges. Sometimes they're where we see a local news story or look on AL.com and we see where a lawyer's been arrested or they do something they're not supposed to do. And we open up a complaint. However we open the complaint or we receive the complaint, we are required by rule to send that to the lawyer. Even if looking at it on its face, we can tell it's frivolous. And I understand that that frustrates a lot of lawyers. We have to send it to you, even if we can tell it's frivolous. And under the rules, you are required to respond. You have 14 days to respond. Now, if you need more time, we always give you more time. But when we have the complaint on one hand and we have the lawyer's response on the other hand, those responses are reviewed by at least 2 lawyers in our office. And if both lawyers agree that this matter is frivolous or either we can't prove it and it gets screened out at that level, then that case is dismissed. In many of those situations, we don't even talk to the lawyer. All we know about the lawyer is what is purely on paper. All right, having not even talked to the lawyer. So if you see the second bullet point, which is the number of screen outs. So last year we received 882 complaints, but we screened out 819 of those. Now, on an average year, we screen out 74 to 75% of complaints on paper. Last year, we screened out over 90% of complaints on paper. So when people ask me, Roman, what do you spend a lot of your time doing? I spend a lot of my time telling 819 people that their lawyer didn't do anything wrong, that their lawyer got it right. I spend a lot of my time defending the practice of law and defending lawyer conduct. So that's a point that I often like to make. Now, we did open up 174 investigations. A lot of those are, some of these investigations go on for a year, and so that's kind of, I've had somebody say, well, Roman, if you take 819, subtract from 882, you don't get 174. Some of these investigations we've had for a while. Some of them are investigations that occur at the local grievance committee level. Some of you probably serve on your local grievance committee. And so that's kind of the reason why we have those numbers there. And then the other bullet point I'd like to point out really is that one at the bottom. The number of ethics opinions that we issued. Last year, we issued 2,250 ethics opinions. In my opinion, out of all the great bar programs that the Alabama State Bar offer, our ability to give you ethics advice is, I think, the best program we offer the membership. In some state bar associations, if you call the bar to get an ethics opinion, they'll charge you for it. Not us. It's free. And I'll talk a little bit more about our ability to give you ethics advice later in the presentation. So, one of the other things I like to talk about, I assume that a lot of people viewing this would be civil litigators, but even if you're not a civil litigator, then some of these next kind of rules that we're going to talk about are applicable. But the first thing I want to talk about is some legal advice, right? Clients come to see you and they come to see you for advice. And I try to tell lawyers, particularly young lawyers, people just starting out, sometimes the best advice to give a client is no. Even if they have a legitimate injury or they've been legitimately victimized in a situation, if there is no legal remedy or that statute of limitations has run, or if the injury is just not substantial enough to create enough compensation to pay for an expert, and you have to have an expert to get past summary judgment, well, then you probably need to turn that case down. If you take that case, hoping that it will settle, hoping that you can work it up cheaply or working it up in a way that is not going to cause you too much time and effort, that case is invariably going to go sideways. The client's expectations are not going to meet the reality, and that's when you're going to get a bar complaint. So one of the things I try to tell lawyers is sometimes the best legal advice you can give a client is no. Now, when we're talking about big ticket items in my office, the number one bar complaint we get is client communications. The lawyer not communicating with their client. And I don't care what your practice area is. You can be a litigator, you can be a bankruptcy lawyer, a patent lawyer, an immigration lawyer, doesn't matter. Client communication is the number one complaint that we get. Now, the rule is pretty straightforward. The A subpart of Rule 1.4 says a lawyer shall keep a client reasonably informed about the status of a matter and promptly comply with reasonable requests for information. Now, look, we understand that your idea of reasonableness and your client's idea of reasonableness are often very different. We understand that if you're sitting in a case where you have a motion to dismiss pending or a motion for summary judgment pending, and the judge just hasn't ruled, and there's nothing you can do until they rule, your client may get frustrated. We understand that, but you've got to make reasonable attempts of keeping your client up to date in their case. Now, when we do prosecute these cases, this quote really is kind of what we see. The single biggest problem in communication is the illusion that it's taking place. I get responses from lawyers. Look, Roman, I sent my client a text message. Look, I sent him a Facebook. I sent him a DM on Facebook and told him that I couldn't be there or whatever. And sometimes that's okay. Sometimes that is reasonable communication. But if a client is coming to see you about something, that it's probably a problem that they're dealing with. And it's oftentimes the biggest problem going on in their life at the time. And sometimes a text message just isn't enough. You need to do a better job of communicating.
I guess part of that is setting up reasonable expectations.
That's true. On the front end, and I try to tell lawyers too, you can get in touch with your client can get in touch with you through so many different vehicles these days. And I try to tell lawyers, you need to manage expectations early. You can be the 24/7 lawyer. You can tell your client, you contact me day or night, anytime, that's fine. You can do that. But I would recommend against that. That is a sure path to burnout. I try to tell lawyers, you ought to set expectations. If you're going to give a client your cell phone number, tell them to text you. It is also okay to say, look, if you text me after 5 o'clock or 6 o'clock, I will not return that text message until the next day. There's nothing wrong with that. I know some lawyers say, well, I'm going to lose clients if I take that approach, whatever. I don't see that. I understand that concern. I don't think most of your clients, particularly, your clients who are reasonable. Right. I was gonna say that because of course therein lies the rub. But I would say manage expectations on the front end. In a close, in addition to poor client communication, procrastination, where lawyers, maybe they do file the case, but they just let the case sit. They don't really do anything with the case.
And that kind of goes back to be careful about what cases you take.
That's right. Case selection on the front end can go a long way towards eliminating a lot of these. But I'll tell you something else about these last two issues: client communication, and then procrastination and diligence. And because that's kind of what we talk about is diligence. Really, an underlying problem sometimes is a mental health issue. We will get a series of complaints against a lawyer, not just kind of a one-off, but we'll get like 3 against a lawyer. And that's kind of a first indication for us that lawyer may have some kind of substance abuse issue. They may have some kind of mental health issue, depression or whatever they're suffering from. And so sometimes when we get into these cases where they don't talk to their clients and they're not pushing their cases, it's because they're suffering. But we all have a rule under Rule 1.3, diligence. A lawyer shall not willfully neglect a legal matter entrusted to him or her. These are situations, again, where lawyers will file the case, but then they just don't push the case. And then, once you do file the case, you've got the obligation to keep your cases moving. A close second to the rule on diligence is Rule 3.2, expediting litigation. A lawyer shall make reasonable efforts to expedite litigation consistent with the interests of the client. Now, let me talk a little bit about that. When we have cases under this rule, disciplinary cases under this rule, I will have lawyers who are defense lawyers in the civil context or criminal defense lawyers. They'll say, Roman, my client's got some exposure. They've got some liability. They've got some criminal liability. They're going to jail or they're going to have to pay money. And it's in my client's best interest never to go to trial. Well, the committee comments to this rule make very clear that is not reasonable under the rules. All right. Delay for the sake of delay, just because it's not in your client's best interest, is not what this rule is talking about. So the underlying policy reason behind this rule, as discussed in the committee comments, is that the American public need to know that if they are the legitimate victims of a crime, or if they have been legitimately injured in some way or have a civil dispute, that there is a fair and efficient court system that can deal with those problems. And when we have delay for the sake of delay, that makes the entire system look bad. It makes lawyers look bad. And that's kind of what the committee comments talk about. And so delay just for the sake of delay, because your client's going to have to pay money or your client's going to go to jail, is not reasonable under this rule. Another thing, fee issues. We do see a lot of fee issues, particularly in the litigation context. One of the things we have to remind lawyers on is you can't share fees with non-lawyers. I think most people know that. We see that violated all the time. But there's been kind of this uptick in these non-lawyer advocate roles we see. The federal courts I think maybe in some immigration cases and maybe in certain kind of disability type cases, we've seen where the court will allow non-lawyer advocates, and not only will they allow the non-lawyer advocates, they'll allow these non-lawyer advocates to submit a fee petition. And so, we personally at the bar don't like that, but if that's what the courts are allowing, there's not much we can do, particularly at the federal level. But here is, if you are forced to work with one of these non-lawyer advocates, make sure that their fee petition is not joined in with your fee petition, and make sure that their fees are not run through your trust account. So if you ever have any problems with that, you can call the bar. We can issue you an ethics opinion on that. But beware if you're being forced to work with a non-lawyer advocate who expects to get paid. The rule on fees says a lawyer shall not enter into an agreement for or charge or collect a clearly excessive fee. Pretty intuitive. The rule also goes on to kind of set out what is clearly excessive. And most of these, the amount of time it takes you to work on the case, the likelihood that if you take this case, you're not going to be able to take other types of cases. All those things are factors that you should consider when setting your fee. Some of the other issues related to fees, if you're doing contingency fee work, it's got to be in writing. All right. There is no contingency fee in the family law context, or if you're handling a criminal case. If you're doing appointed work, you can't be appointed by the court and then also take money from your client. All right. You can't do that. And we see that periodically. Also be careful of flat fee cases. We have a lot of lawyers who are saying, you know what, I don't want to really deal with the timekeeping as much, so I'm just going to charge a flat fee. And flat fees are okay, but flat fees don't exempt you from all those factors we were talking about in the previous slide. So if you do a flat fee case, we still have to look at all those factors to determine whether or not your flat fee is reasonable under the circumstances. Also, if you're going to associate counsel, make sure you get your client's permission to do that. That's really more of a disclosure issue as opposed to a fee issue, because if you're going to involve another lawyer, you need to have your client's permission to tell that other lawyer about their confidential information. And then lastly, we try to work with lawyers. If you do the work, we want you to get paid. All right. We're not out there trying to get you to cut your fee in any way, shape, form, or fashion. If you do the work, we want you to get paid. However, you've got to watch out if you're trying to take security interests in property to secure your fee. Now, you can typically do that, but you can't do it. You can't take a security interest in the property at issue. So, for example, if you're fighting over a piece of property, you would not be able to take a mortgage on that property to secure your fee. All right. You can't take a security interest in the property at issue in the lawsuit. And I don't know if this is an effect of COVID, but this is another kind of thing that we've been dealing with a lot lately. I talked about flat fee work, how you can do flat fee work, but there's no such thing as a non-refundable retainer in Alabama. We have a number of formal opinions on this. I had a lawyer that had been practicing law for 30 years the other day, required a retainer, and then settled the case pretty quickly. And then the lawyer said, I want a refund of my retainer, and I want an itemized copy of what your charges are. And then the lawyer, in his response to the bar complaint, says, well, I didn't keep my time because I told him it was a non-refundable retainer. And that's what he said. That was his response to the bar complaint. He'd been practicing law for 30 years. And I said, well, can't do that. Showed him the formal opinions. So that's kind of something that we've seen a lot lately. Another thing that we see, we'll go 6 months without having one of these cases, and then for 6 months, this seems like all the cases that we have. But we do see, this is where we see the litigators more than other people. It's truthfulness in proceedings. It's where you're not telling the court the truth. Rule 3.3, again, another rule that's pretty intuitive. It says a lawyer shall not knowingly make a false statement of material fact or law to a tribunal, fail to disclose a material fact, or offer evidence that the lawyer knows to be false. All things pretty straightforward that everybody kind of knows in law school. But I think what we're seeing is, as we move to more Zoom hearings, I say move to them, we've been doing them significantly for a long time. I think people are more emboldened. When they're not in the physical presence of the judge, they're not in the physical presence of opposing counsel or their client, then they take more of a liberty with the facts. And I think that's what it is. I think it's the separation and the distance that's being caused by Zoom hearings. Another thing that you need to know in terms of candor towards the tribunal are, what are your obligations to rectify any false statements? So if your client, for example, lies on the stand or lies in the deposition, and you submit that deposition as part of a summary judgment motion, how long do you have the obligation to rectify that once you find out about it? And so the rule basically says your duty to rectify the misstatement or the falsehood really lasts until the conclusion of the proceeding. And so typically we interpret that to be, does your trial judge still have jurisdiction? If your trial judge has been divested of jurisdiction, and even if you tell your judge about this, make this disclosure and tell the judge about the falsehood, can the judge in fact do anything? If they can't, if they lost jurisdiction, then your obligation to report no longer exists. Now, I will say this: be careful of the law of equity. All right, in certain circumstances, equity may toll a statute of limitations, or may toll a statute, or may increase the judge's jurisdiction. So just be careful there. Again, this is a great area where if you do have a question, just call us. We'll give you the ethics opinion. We'll walk you through what you should do. So, and when we're talking about candor towards the tribunal, I built a slide a couple of years ago that I used in a trial ad class that I taught. And, we have a perception problem, right? I mean, as lawyers, the entire legal profession has been under attack. And so there's this idea about what lawyers are and who they are. Well, this is a poll that I kind of built a slide off of, and it ranks all these different professions. So I tell my students, the modern day trial is about credibility. It's about your credibility. And those jurors are watching you from the time you get to the parking lot until the time you do your closing argument. And so if you get caught not telling the truth or in some way misleading the facts, you will sink your case and you will sink your client almost immediately. I tell them, when you walk into that courtroom, you're that 19%. That 19% right there, that's who you are. At least that's who they think you are. And the truth is, if you're the plaintiff's lawyer or you're the criminal defense lawyer, you're probably closer to that 13%. You have no room for error when it comes to candor towards the tribunal or candor when you're arguing before the jury. Another thing that we see, again, really more with litigators, are where, another thing, and this is another fact pattern where when we see these, there's almost always a substance abuse issue, a drug issue, a mental health issue. When we see lawyers doing this, there's something going on that's making the lawyer want to use this scam. And when we call it a scam, it's really a situation where a lawyer settles a personal injury case and they disperse the money to the client like they're supposed to under the agreement, but then they retain some of the funds because they're trying to negotiate the liens associated with the case. And so instead of holding that money in their trust account, they use it for improper purposes. They pay bills with it or whatever. And so we tell people, you can't do that. I realize that there's this faceless insurance company on the other side. It's easy for you to in your mind, get your head around that this really isn't somebody else's money. That's not true. It is someone else's money. And we see lawyers lose their license for it every day. And in addition to not only losing your license, the attorney general is prosecuting people for this and sending these people to prison. And so when I tell them, I'm like, I know you took this money thinking that the next settlement was going to come in, you're going to put that money back. It's not just an ethical violation that'll cost you your license. It will cost you your liberty and your freedoms. So that's another scam that we kind of see. Again, since we're talking about litigators, talk about deposition ethics. We see a lot of different things, but one of the things we see from a litigation standpoint is where someone will come in and they'll say, you know what, I represent this person for the purposes of the deposition. That's it, just for the purposes of the deposition. And usually where we see it on the plaintiff side is someone represents the injured party, but then a family member is somehow a witness. And so they're going to represent that witness just for the purposes of the deposition. Or on the civil defendant side, where someone represents a corporation and an employee of the corporation is a witness, and they say, and when that employee is deposed, they say, well, I'm representing this witness just for the purposes of the deposition. The truth is, in both situations, you probably don't ethically represent that person. And if you do, you got to comply with Rule 1.2 and Rule 4.2. So Rule 1.2 is our rule on limited scope of representation. And it says a lawyer may limit the scope of the representation if the limitation is reasonable under the circumstances and the client gives informed consent. The client's consent must be confirmed in writing. All right. And there are obviously exceptions where it's just a telephone consultation are you doing pro bono work, or you're appointed by the court, or there's a court order, but if you're gonna represent someone just for the purposes of the deposition or just for any limited purpose, that needs to be in writing. And if it's not in writing, then you may have some problems, because under Rule 4.2, when we're talking about an opposing counsel's ability to talk to that individual, the B subpart to Rule 4.2 says a person to whom limited scope representation is being provided or has been provided in accordance with Rule 1.2C, which is what we just read, is considered to be unrepresented for purposes of this rule unless the opposing lawyer has been provided with a written notice of the limited scope representation. So if you have someone on the other side of your case that says, hey, I represent this person just for this limited purpose, then you say, where's my writing? Right? Where's the writing that says that this is what you're representing them on and how long you've been doing it or whatever, have to have some material and reasonable terms. And if they don't give that to you, then you have the authority to talk to that person outside the presence of the lawyer. Now, got to be careful there, right? I mean, there's a lot of gray area there that can get you in trouble. But again, if you've got that situation, I'd love for you to call us and we give you an ethics opinion. Let me talk briefly about a case that we prosecuted under this scenario. But we had a civil defense lawyer who represented so he was representing Corporation A and Corporation B over the sale of some assets. And key to this sale was one employee who worked for both A and for B. They had sold it to a third party, the third party plaintiff, and the plaintiff was suing Corporation A and Corporation B. Lawyer represented A and B. So everybody wanted to depose this employee. The lawyer who represents A and B goes to talk to the employee and gets all the confidential information from the employee. And then as they are leaving the deposition prep, okay, this is the day before the deposition, he's meeting with the employee, preps it for the deposition, gets all the confidential information from the employee, and then at the end says, oh yeah, by the way, I don't actually represent you, I represent A and B. And the guy gets really upset. But then he goes forward with the deposition anyway. And at the deposition, the lawyer who represents Corporation A and Corporation B, and he's sitting next to the witness, says, objection, attorney-client privilege. I'm going to instruct him not to answer that. And then on a break, pulls the employee out into the hallway and gives him legal advice as to how he should answer a particular question. So we tell this lawyer, I'm sorry, you are his lawyer. Ultimately that's what we told him. But they go to trial in this case. Now this lawyer does a great job of lawyering. He gets Corporation A and the employee out of the case without having to pay him. Just a clear release, and really in the Corporation A's benefit, really in the employee's benefit. He does a great job with him. But the whole theory at trial, when they go to trial against Corporation B, is that the individual employee is a liar. He's a cheater. He can't be trusted. And he discloses a lot of confidential information about that employee, showing that employee is really not a good person. All right. If that person is your client, you can't do that without your client's permission. You cannot throw your client under the bus without their permission. Now, I know this lawyer says, well, he wasn't really my client. No, he was your client because of the way you acted and you treated this individual. So, again, another great area where if you've got a question, you'll call us and get an expert opinion. We talked briefly about another thing I've been spending a lot of time on. And again, this is the direct result of a lot of lawyers who are struggling, either with some type of mental health issue or substance abuse issue. And it's when lawyers get in trouble because of what they do in their own personal life. So the question I get is, can an Alabama lawyer be sanctioned for private conduct? And the answer is yes, you can. So we usually prosecute lawyers for their personal conduct under two subsections. 8.4D says it is professional misconduct for a lawyer to engage in conduct that is prejudicial to the administration of justice. That's usually situations where someone is getting involved in a case that's not really their case, or it's a cause that they're not litigating over, but it's a cause that they feel strongly about. They get into trouble. But more commonly, we prosecute these cases under 8.4G. It is professional misconduct for a lawyer to engage in any other conduct that adversely reflects on his or her fitness to practice law. Very common 8.4G cases are where attorneys get arrested. All right, that can be a DUI, that can be a domestic violence, that can be drug charges. Social media outbursts, where lawyers take to social media and they say some really outrageous, racist, sexist types things that really get lawyers into trouble. And then any other really outrageous conduct, although it may not be subject to a criminal penalty, it may get you in trouble with our office. Another thing we spend a lot of our time on is breach of confidentiality. I talked earlier about confidentiality in Rule 1.6. Pretty straightforward rule. Lawyers shall not reveal information relating to the representation of a client unless the client consents after consultation, except for disclosures that are impliedly authorized in order to carry out the representation. Pretty straightforward. Where I'm seeing the problems are in the area of social media. So here's a case that we prosecuted. Lawyer gets an anonymous post from a client, former client, on Avenu. And although it's anonymous, the lawyer responds back, to the negative review, and he says some really bad things, very disparaging things about his client. So the quote is down there. I mean, he said he talked about his client's DUI, his client's drug charges, his client's mental health issues, and just a lot of things that were very inappropriate. So again, I know I sound like a broken clock. If you get this type of negative review, we want you to respond. We want you to protect your good name, but there's a way to do it and a way not to do it. All right, you can't reveal confidential information. And so this is a point I also like to use this fact pattern to point out that your duty of confidentiality is much broader under the rules of professional conduct than the attorney-client privilege. As most of you know, the attorney-client privilege is a rule of evidence. All right, whether something is or is not the attorney-client privilege, that's within the purview of your judge. Whether or not something is confidential is within our purview. All right, and it's much broader. So for example, in that last fact pattern, the fact that this person has had a DUI and drug charges is probably public record. All right, that's probably not attorney-client privilege information, but that is confidential information because it's not in your client's best interest to be disseminated. And so, and you may not have even known that, but for the client representation. So that's an example of how your duty of confidentiality is much broader than the attorney-client privilege. One other thing before we leave social media, if you are a person who's very active on social media, be careful on the information that you put out there, because oftentimes you'll post an article or you'll post something and someone will respond. And when they respond, they give you information that probably you shouldn't have. But then, and even worse, sometimes you respond to that post and you may inadvertently create the attorney-client relationship. And if you inadvertently create the attorney-client relationship, well, then you have the entire burden of that attorney-client relationship, and you have to meet all of the duties that go along with that. Also, in litigation, there's oftentimes the exchange of massive amounts of data. In some situations, you get discovery requests that specifically request documents in their native format. And if that's what the order says, then oftentimes there's a protective order that goes along with it that protects a lot of that information. But you need to know about metadata and know about what metadata is, because when you create a document in its native form, oftentimes there are prior versions of that document still on the native format. So for example, if you are using a lot of forms, whether that be bankruptcy or that be probate proceedings, or even, any type of motion for summary judgment, there may be metadata embedded in those documents that pertain to other clients. And so the lawyer on the other side may not have a right to that information. So you need to know about metadata. We issued an order back in 2007 that basically says, under Rule 1.6, your duty of confidentiality, you have to use reasonable care when transmitting electronic documents to prevent the disclosure of metadata that contains client confidences or secrets. So you have an ethical duty to not send confidential information out. Now, that duty works both ways. If you receive a document in its native format, you have an ethical duty not to mine that document for confidential information. All right, it works both ways. So let me kind of finish with, again, what I say is the best service that we offer the membership of the Alabama State Bar, and that's our ability to give you ethics advice. A lot of you probably work with a lot of really good partners, very experienced partners. Oftentimes you have a relationship with somebody in law school that was just brilliant. They know everything, and you rely upon them for all types of advice, and that's great. And you should maintain those relationships, but you maybe shouldn't rely on them for ethics advice. And there's really no reason why you wouldn't call us if you are talking to that person about your ethical concerns. So my ability to give you ethics advice and our office's ability to give you ethics advice really stems from Rule 18 of the Alabama Rules of Disciplinary Procedure. Under Rule 18, if before engaging in a particular course of conduct, not after, but before, you give us a full and fair disclosure of what the facts are, not what you hope they are, or you want them to be, what you reasonably understand the facts to be, we will treat that confidential. And remember, we take this duty of confidentiality very important in our office. And so, but let me drill down on that a little bit. Here's what that means. When you call us to get an ethics opinion, if your judge calls us and says, hey, I told this lawyer to call and get an ethics opinion, did he or she do it? We have to politely decline and say, Your Honor, we can't give out that information unless you authorize us to. Same thing if opposing counsel calls or your client calls and says, hey, they're telling me this at A, B, and C. Did they call you and get an ethics opinion? We have to politely decline and say that's confidential information. We can't say whether or not we did or did not, again, unless you disclose it or allow us to do it. I'm sorry. So, but this is now it's confidential just to us. Once we give you the opinion, we can give it to you in a lot of different formats. We can put it in an email. We can put it on letterhead. Once we give you that opinion, you can do with it whatever you want to do. All right, you can put it in a motion, submit it to the court, whatever. So we will treat all your inquiries confidential. And then we will give you a proposed course of conduct. We'll tell you what you should do. And if you follow our advice, then we won't prosecute you. That's about as good of a get out of jail free card as I can give you. So David, I see that we've got about 5 minutes left. We're going to hold that open for questions. Do you have any questions for us?
Absolutely. But first and foremost, I want to thank both of you for bringing us a very thoughtful and thorough presentation. And personally speaking, I learned a lot of new information today about the Alabama State Bar's programs and initiatives that, frankly, I wasn't aware of. And my two takeaway messages from your presentation today are these. First, if a lawyer in this state needs help, the Alabama State Bar is ready and willing to give them that help. And second, lawyers don't need to wait until a personal or a client-related problem becomes a career-threatening problem. Reach out to the bar for help at the first sign of trouble. So you guys have given an exhaustive presentation, and as of right now, we don't have viewer submitted questions, and I think that's a testament to how thoroughly you guys have covered it. You answered my question. My question was going to deal with the ins and outs of reaching out to and communicating with current and former employees or officers of an opposing party. You guys did a fabulous job of that. So I'll tell you what I'll do. Let me go over a few final housekeeping notes before we conclude today's presentation. And again, I just want to thank our two presenters for doing such a great job. For those of you who may have missed our earlier announcements, by the end of this week, you'll receive an email with an evaluation form and an updated presentation and our video link. You can email that completed evaluation form to webinars@beasleyallen.com. Again, for those of you who are participating by phone, please email us your name, phone number, and state bar ID number. You can send that as well to webinars@beasleyallen.com. That'll help us ensure that you receive full CLE credit. Again, got to put a plug in for our events page. We are adding webinars throughout the year, throughout next year. Our next webinar will be the Camp Lejeune update. It will be our third update. It's a very popular subject, and it's one that many have asked us to reprise, so we're going to do that. That's scheduled for Wednesday, November 30th at 12 p.m. Central Time. I want to thank everyone for joining us today, and thanks to all of you for supporting our Beasley Allen webinar series. Have a great day.
Thanks, David.